start the discussion. So we're going to really cover two key things today. Um, First thing is we're going to talk about what is intellectual property, but not just sort of the theoretical part. We're going to actually go through and do some examples of identifying what your intellectual property is and then how we can protect it. And then the second part is really talking about the value of IP to a startup or to an entrepreneur and how to capture it, and also how to issue spot, how to make sure that we don't have problems or run into issues later on. So that's sort of the things we'll be covering today. And that's really it. I mean, it should be fairly straightforward, but each of these topics will dive into things that will affect your company and your ideas moving forward. So first thing we do is identify, is it a patent, a trademark, or what? And the reason we do this is because when we're talking with entrepreneurs and startups and companies, there's two types. So when I was consulting in the private sector or even doing workshops in the region or in the US with startups and incubators, accelerators, I always found there's two types of people. One, people that had really cool ideas, and then people that actually had assets, that had clear plans, ideas that had morphed from just a cool idea they'd come up with to actual legal assets that could be transferred and sold. And so that's what I like to talk about as my theme when I'm talking with any startups or entrepreneurs, is taking your ideas and making it into a clear legal asset that has a legal scope and has rights associated with that, and then building a portfolio of those assets. And we do this because we'll talk about this later on, but I want to bring this idea up first. Think about the perception of you as a company or you as a new startup, as an entrepreneur. You're talking to an investor, talking to customers, and you say, look, here's my idea. And let's say that another one says, well, here's my 15 legal assets that I've created based on things I've created. Which of those two companies looks more attractive? And so that's our goal today. It is showing you how to take those ideas, create assets, and then use those assets to make your company more competitive against other people. So that's today's goal. So how do we take ideas and create assets? Well, before we talk about how to do that, and we talk about intellectual property, the way that I love to teach intellectual property is talking about something that we all know first, which is real property, which is land. So how would you take a piece of land and make a legal asset from that? So how would you take this sort of idea of maybe a land or a car or apartment or a piece of property, and how would you make it into your portfolio of assets that you own? And so this is the scenario I like to walk through with anyone before I talk about intellectual property. Is you're walking down a road, and on your right, you see this really cool piece of land. And you say to yourself, okay, I want that land, I want to own it, and I want to use it, and I want to sell it. Well, how do you do that process? Do you just go and like stand on that piece of land and you wait for like 3 hours? Or maybe you put a tent on it and you camp out for 3 weeks. Does that mean you own the land? No, of course not. You have to do certain procedures to transform that piece of property into something that you own. So one thing you might have to do is first see, does anybody else own that land? Because if someone else already owns that property, you can't own that property. So that's one thing you might have to do. So maybe going to the local government, doing a land search, seeing if that property had been bought or sold in the past. But let's say that it's never been owned before. Let's say it's a new piece of property that no one's ever seen before. Okay, well, how do you then prove that you own it, and how do you prove that this is your property and not someone else's? So for a piece of land, what you would normally do is you'd go out and you'd conduct a survey. You'd have people come in, define the boundary of that piece of land that you want to own. Maybe they might describe it, saying over on this side of the hill is a stream, and on this side there's a pond. There's some forest over here, and it ends the piece of property ends on this road. So that's one way. But another way to describe that piece of land is by doing a detailed scientific and mathematics survey. So using the little radar tools to define the distance of the land, the height, the width, maybe with even GPS coordinates to create a mathematical boundary of what is your piece of land and what is someone else's land. So even after you do that, is that enough? Now that you have this document that says this is the boundary of the piece of land that I'm claiming, is that enough for you to have rights in that land? Again, no. Again, you still have to do one more important step, which is you need to then go to the government that has that land within its boundaries and tell the government, hey guys, I want this piece of land. Here is the boundary around the land. I've already done a search and no one else has owned the land, and I'm willing to pay the government this amount of money to register that land. Because in most cases, the only entity that can give rights in a piece of land is the government. And so that's the process that we would normally do for finding a piece of land and making it an asset, so that once that government issues you a document or a title to that piece of land, now you have rights in that land. And what rights are those? Well, it's the right to use the land. It's the right to build on it. It's the right to stop people from trespassing onto your land. And it's the right to sell that piece of land or rent it or lease it to other people. So until you have that government document that says you have legal rights to this piece of land, it's just you and maybe your tenant standing on that piece of land and trying to sell it to someone else. And that's sort of the same way that I see some types of startups or entrepreneurs trying to sell just ideas to people versus a legal document that says I own this piece of land. So that's the scenario. And then here again are some of the key words that we like to use when we talk about real property. And this will come into importance when we transfer over to intellectual property. So in real property, we have the term real property, and that's what the property we're looking at. So in this case, land. But it could be an apartment, it could be a car, it could be anything physical that you'd want to own, being real property. And then the next term is real property protection. So that is the legal document issued by a government, issued by maybe a bank or someone that says this piece of land or apartment or car is owned by this person. So that's the protection that real property has. And then once you have that protection, now you have rights associated with that. So real property rights. So again, it's important to really make sure we understand this first. Real property protection, and then real property rights. Because in a moment, we're going to switch out the word real for intellectual. And then hopefully this will help drive home the point of the similarities between a piece of land and an invention or a brand. So then with the rights are associated with the piece of land, we said the right to use, the right to stop people from trespassing, the right to sell it or lease it or rent it. And what does that document look like? So this is an example of a fake deed. So for a piece of land, often we call the document that the government issues that says you own this piece of land, we call it a deed. And in this case, this deed of land on the left side describes the piece of property using words. And then on the right side, this provides that geographic mathematical description of what is the boundary of the piece of property that you own and what's not your property. So this clearly shows that this person owns everything within inside that box. So let me pause there quickly. Are there questions about going through the example about real property protection, and real property rights? Because our next step will be jumping into intellectual property and how that compares. Questions so far, but please use the text box.
You can also raise your hands, guys, if you would like to speak to Peter.
Yes, please.
Okay, I think we're good to go.
Okay. All right, so we're going to move from real property to intellectual property. So same scenario, but this time you're walking down a road, but the road is in your mind. So visualize yourself walking down a road in your mind. You have all these ideas, all this information, and you again want to take one of those ideas and make it a legal asset. So again, when you looked at the land, could you just stand on that piece of land for 3 hours, 3 days, 3 months, and get legal rights to it? No. Same thing when you talk about intellectual property. So you're walking down the road in your mind, and let's say that you have discovered a new invention. Let's say the invention is a improvement of the iPhone's camera that you have determined because you are an expert in optical technology, and you've discovered that if you improve the iPhone's camera in this way, it's going to be better. So that idea is in your mind somewhere. So as you're walking through your brain and you come up to this invention, how do you take that invention from your mind and create a legal document, a legal asset that you have rights to? Do you just write it down on a piece of paper, hide it in the closet, and that's it? Or what about you just keep it in your mind? You don't tell anybody. No. Again, it's just like the scenario with the piece of land. You would need to go through the process like you would the piece of land in order to get rights to that invention for the camera. So just like with the piece of land, you might want to first do a search to see if anyone else has already discovered that piece of property, that intellectual property. So you might do a patent search. We'll talk about what this is later on. Or let's say you came up with a new logo for your company. You might also want to do a logo search to make sure that that logo is not being used for something else or something similar. So once you do that sort of search to make sure someone else doesn't own that piece of property, then what was the next step we had with the piece of land? Was to clearly define what your piece of property is. What is the boundary around it? And making sure that boundary is very clear. So in this case, what we want to do for the invention is we want to file a patent application. And again, we'll talk more about these details later on, but file an application with the government that clearly defines what that boundary of your invention is and what's inside that boundary. So what do you believe is your invention and what do you believe is outside that invention? So creating that boundary of what that invention is. Once you have that boundary, then you can file a document with the government and say, hey, governments, I now want to register or protect this piece of intellectual property that I've discovered. And most likely, here is a fee for that transaction. And then the government, just like it would have to do with a house, probably have to do their own search and make sure that you are the first person to invent that piece of property and that no one else owns that property. And then they might say, you're right. No one has owned this property before, and we as the government are going to give you legal rights to this piece of intellectual property. And here is a document that proves that you now have rights to that invention, to the camera, or to that new logo. So that's a very sort of similar way to talk about how you would get rights in a piece of land and how you would get rights in an invention or a brand or other type of intellectual property. And so I think this is a good way for that. I mean, I use this to talk about intellectual property with really any type of audience, because we are all quite familiar with how land works and how land rights work. But often there's confusion of how do we take an idea or a creative work or a brand and create a legal right out of it. But it's just the same way. You identify it, you make sure no one else owns it, you create a border around that piece of property, defining what's your intellectual property and what someone else's, and then you register that right with the government. So that's really generally how we talk about intellectual property, and for startups, at least an introduction into what we're going to talk about later in terms of identifying your intellectual property. So using, very similar terms that we looked at for real property. So first is the type of intellectual property. So with the land, which is one type of real property, but again, it could have been an apartment, a car, maybe a new dishwasher, or other piece of property. With intellectual property, we have a few general kinds we like to talk about. We have an invention, we have a creative work, the identification of a good or service, so that'd be like a logo. We have just information generally, data. We also have industrial designs, so ornamental features of things. These are types of intellectual property. And then just like with real property, you want to protect it. So what are the protections called for the types of intellectual property? So for patent, that would be the intellectual property protection for an invention. Trademark would be the intellectual property protection for an identification of a good or service, like a brand or logo. Copyright, again, the intellectual property protection for a creative work. And I keep saying these terms over and over again because when you talk about a house, the type of real property protection might be a deed to the house, whereas the type of protection for a car might be a different type of protection, similar to a piece of electronics you might buy for your house, or for an apartment, or for a commercial building versus a residential building. So each of those types of properties will have a different type of protection, and each of those protections will have a different name. And then once you have the intellectual property protected, you have that registered legal right. Now you have the opportunity to prevent others from using it, just like with a piece of land, you have the right to prevent people from entering your land if you don't want them to be there, from trespassing. You also have the right to transfer that intellectual property asset. So you can sell someone your trademark, or even just license it or rent it. Same with a invention or a creative work. But until you actually have a legal right, there's nothing that would stop someone just from taking that intellectual property from you. Again, just like with a piece of land, if you go and just stand on a piece of land, but don't go to the government to get legal rights, someone else can come and stand right next to you and then start getting legal rights to that piece of property and then probably be able to kick you off. So this is why it is so important for startups and entrepreneurs or anyone who's creating a new company to really make sure that you're taking those ideas from your head, because there's some amazing ideas and some amazing creative work going on, and making these amazing companies with logos and brands and high quality work. But often those types of intellectual property is not being protected, is not getting a government issued right, and is then being sort of open for others to come and stand on that piece of property and either take rights away from the person staying there originally, or even going and registering their own rights for something else. So that's why we want to talk about this very seriously in the context of startups. And then just like we saw that there are documents for protecting land rights, there's also documents that can say that you own pieces of intellectual property. So these are examples in the US. So we have a copy of a US patent on the left, and then in the middle is a copy of a copyright certificate. It says you have rights to a creative work. And then on the right is a copy of a trademark registration. So again, these are the same types of documents that for a piece of land would be a deed that shows what you own, but this is just for your intellectual property rights, the assets. Questions so far? Oh, we have a question. Does an idea have to be developed to a certain extent before it can be turned into an asset? Or can any idea be registered as an asset? Great question, and perfect for our next slide. So the question asked really is, can you protect ideas, or does it need to be a little bit more? And the answer is yes, it needs to be a little bit more than just an idea. So for the different types of intellectual property protection, they have a very clear definition of what they can protect. So for a patent, and patents protect inventions. What does that mean? So internationally, the definition of what an invention is a process, so like a method of doing something, or a machine, so like a device, a manufacture. So this is taking a piece of material and bending it, heating it, altering it in a way that changes the structure into something new. Or a composition of matter, so combining a set of elements together. So those are things that can be patented. So if your idea, the picture is not coming through. I appreciate the comment, that's good. Let's try this. All right, the picture's back up.
Maybe problem, but it's clear to me. I can see the slides. Yeah, Peter.
Fantastic. So going back, so the patent, again, this protects the inventions. And as we said before, the invention, again, has to be a process, machine, manufacture, or composition of matter. So if your idea fits within one of these categories, then a patent could be a way for you to protect that invention and create a legal asset from that. For patents for inventions, they have to be new. So that means they have to be new not just in Bahrain, but new globally. So if someone has invented or created your invention somewhere else in the world, you can't get a patent on it anywhere else. And it's not just new, but it also has to be not obvious. or have an inventive step associated with that. So that's a good example of that is if someone had created the first chair and they made the chair, they put the chair together using nails. And then I changed the nails into, let's say, screws or glue. That might be an obvious change because people often exchange nails or screws or other types of adhesives, but the chair is still the same. So it has to be new, and it has to be inventive or not obvious, change from other past inventions. And patents, the protection of the patent isn't forever. It's only 20 years from the date that they file the patent application. So just like for the piece of land, when you file your registration with the government to get that protection from the land, same thing here. You'd file your application to get a patent, and once the patent is granted, you didn't have rights, but those rights start from the date you filed the application, and you have 20 years from that date to stop anybody else from making, using, selling, or even importing that invention into your country. So, but let's say that your idea is a brand. Let's say that you came up with your company, and again, we'll stick with the example of the camera for the Apple phone. So you've created a new camera, and you want to identify that camera with the name of your company, and you have a logo with that company. Well, that idea that you want to create a brand or logo, well, you can protect that brand or logo using the intellectual property protection called trademarks. So then trademarks protect the source or identity of a good or service. So, I mean, easy examples are, I'm just looking around me right now, like the Apple logo on my phone. There's some, on the TV, there's logos there. On the food in my kitchen, that has brands or logos. Each of those is a trademark, and you'd protect that brand or logo so that no one else could use that logo for their own goods or products. So that's another type of idea that can be protected using intellectual property, because that idea is something more specific. It's a brand, it's a logo, it's a company name, it's an identifier of whatever good or service you're making. And unlike patents, which are protected from 20 years from date of filing, trademarks are generally protected for 10 years after the application is registered. But unlike patents, which can't be renewed, trademarks can be renewed generally every 10 years, and generally for as long as the trademark is being used in commerce. So if you stop using your trademark, most countries have laws that say after a certain period of not using your trademark, someone can come in and cancel your trademark registration and use that mark instead of you. So that's a trademark. The next type of intellectual property protection is for creative works or artistic works. So a painting, music, poetry, film, but also computer code. And what copyright protection does is it protects those creative works generally from the life of the author plus 50 years. In the US, in some countries that want to encourage more creative works, the length of protection is 70 years. So again, it's not just 70 years, it's the life of the author plus 50 years or plus 70 years. So it's a pretty good protection, and it allows the families of the authors to also protect the work even after the author has passed away. So anything that's artistic or creative, but not functional, then that can be protected by a creative work. And you might wonder, why is computer code in here? So what does computer code do? Computer code does a function. A coder comes in and you tell them, hey, I need you to program this machine to do this function. Well, we learned from a patent that the process or function can be protected. But what is the computer code, though? The computer code is simply the creative way that someone decided to do that function. So let's say the function is, let's say for this camera idea that we came up with, that I'm the owner of this camera company, and I need the camera to interact with the phone so it'll work. So I need to hire a coder to program a method or a process that allows the camera to quickly connect with the phone and to download procedures from the camera directly into the phone so they can work together. Well, that's a method of doing that. But is there only one way to write that code? No. There are many different coding strategies, coding preferences, different languages, different variables that the coder can use. Maybe the coder likes to call all of its elements apple or dog, because that's the way that they feel is a creative way to make their code more understood. So using creative ways to call different variables or different functions, or they like to always code in this one method. And so what computer code actually is, the code itself, it's a creative work. And so that's why we capture the code itself under copyright protection, but we protect the way the code functions under patents as a process. Question we just got was, how different does the code have to be for it to be considered unique? Great question. There's some fairly prominent cases in the US right now, but also globally, about what does it mean to copy code, and to what extent can you copy code but also change it by a little bit and be okay. Each country is a little bit different of what that means, but generally it's if they are copying the majority of your code, including the way that you call different variables, the way that the code is organized, that would be fairly consistent to be considered copying the code. If they just copy certain algorithms, but they leave out the creative organization or the way that you call different functions, but are just focusing on the function itself, probably not copying the code. But if they just came in and just copied pages and pages of it, that would be a good indication that they are infringing your copyright. But if they simply use different code for the same function, then they are not copying your code. This is why for a lot of software developers or even app developers, I often encourage them not only to protect their code using copyrights, but also try to protect the function using a patent. That way that someone can't come in and just quickly change a few lines of code here, a few lines of code there. But with a patent, you'd stop them from doing any type of coding as long as it has that same function. But at the same time, it's also very important to protect it using copyrights, because I'll be very honest, people who are dishonest and want to copy someone else's work are generally lazy and want to do what's the fastest way that they can copy something. So often I'll see them just simply copy the code line from line and put it into their work. And so having both strategies to protect your work is very important. So great question for that. Thank you so much. So that's copyright, right? So again, patents protect inventions, trademarks protect the identifier of your company, copyrights protect creative works. Next one, industrial designs. So industrial designs protect the ornamental features of an article of manufacture. So what does that mean? What's an article of manufacture? An article of manufacture really is generally anything that you'd buy at a store. Is it be a chair, a table, a lamp, a desk? I'm looking around me, a vase, a bottle, even shoes. It's anything that you are doing something with as a function. And so what do industrial designs do? They protect the way that those articles of manufacture look. So in your house and your friend's house or family's house, does every chair look the same? No. Chairs are shaped differently. And why is that? Because it looks nice. Because having different designs makes it unique, makes it fit into the house better. It makes things look better. But it's still a chair. You still sit on it and hopefully it doesn't break. So what does the ornamental features do? It makes things more attractive, makes you want to buy them, makes you want to put them in your house because maybe it gives you a more relaxing feel. Well, so far, under patents, they would just protect the machine, so the chair itself, so the function of a chair, having a back, having a place where you sit and some legs. Well, it doesn't protect the design. And then for copyrights protect artistic work. Is a chair that you would maybe find in a store and sold hundreds of chairs, is that an artistic or creative work? Most scholars say no, it's not, because has functional work. And so what industrial design protection did is it created that gap, is it solved the problem of protecting the function of the chair versus is a chair a creative work, and said, we don't care, but we're going to protect the ornamental features of that chair. And so that's what industrial designs do. And this is why it's really important for a lot of entrepreneurs and startups that are really being creative in the way that they're creating new projects and new products. And it's not just the physical design, but over the last, say, 10, 15 years, most governments see that industrial design is not just physical, but it's also digital. So the graphical user interface of your mobile app or the way your software opens up on a computer, or even some virtual reality environments. Courts and governments around the world are saying that these are pieces of industrial design because it's industrial design in the digital age. And those features can be protected using industrial design protection. And often we see the protection lasts for 15 years from the date of registration. But again, one thing, just like patents, industrial designs, they have to be new. So you have to make sure no one's ever done your design before of your product. So that's patents, trademarks, copyrights, industrial designs. The next one we'll talk about is trade secrets. This is a bit different. So with the patents, trademarks, copyrights, industrial designs, this fits within the description of how we would protect a piece of land, where we would go out, we would define the boundary, and we would register with the government, submit an application to say, this is our property, we want protection for it. And what happens with those protections is for a patent, copyright, trademarks, industrial designs, the reason that the government is going to give you rights is because you as the applicant are submitting that invention, that brand, that artistic work, that design to the government, and the government is going to publish it so that everyone can see what those rights are, and everyone can learn from those rights to make new inventions or follow-on technology. So it's really a balance. It's the government saying, okay, you can have limited rights to your intellectual property, but you're going to have to disclose that intellectual property to the public so they can benefit from it and they can make new works or inventions based on that information. Trade secrets is different. Trade secrets is the opposite of patents. Whereas a patent, you would file an application, publicly disclose your invention, and get 20 years of protection from the government. The idea of a trade secret is you would not disclose it. You would keep it as a secret. So a trade secret is any commercial advantage that is not generally known or identifiable or ascertainable. So it could be data. So if you're a company and you have a customer list and you've spent a lot of money developing a customer list, that's a commercial advantage that's hopefully not known by your competitors. And you would want to keep that customer list a secret. Well, would you want to register that customer list with the government where it could possibly be published? No, because that's not worth it for you. And also doesn't fit within a patent or copyright or even industrial design. And so what you want to do is you want to keep it a secret. And so what does trade secrets protection provide you? It says that if you as a company or you as a startup identify data or any type of commercial advantage, it could be an invention that is not known and has economic value. If you take steps to keep it a secret, so let's say you put that secret in a safe and you only give 2 people in your company the combination to that safe, or you make your employees sign non-disclosure agreements to stop people from spreading that ideas. But if someone steals that trade secret or misappropriates that trade secret, there is a legal government right that you can go after that person that stole or misappropriated that trade secret and get penalties from that person. So it's sort of a anti-theft measure for intellectual property. That's generally what trade secret protection does. But again, to be a trade secret, in order to have this protection, again, it must have a commercial value and it must not be generally known. And then that company must put in procedures to make sure that trade secret stays safe. So let's say that I have a trade secret. Let's use the classic example of a trade secret, which would be the formula to Coca-Cola. Let's say I'm the Coca-Cola company and I have the trade secret, the formula, the ingredients to Coca-Cola. And I keep it in the safe and I only allow 5 people in the world to access it so they can mix the ingredients together to create the syrup. Let's say that one of those 5 people is also under a non-disclosure agreement that they have signed with the company, and they go out and they sell those ingredients to Pepsi. Well, in this case, there was a trade secret because it was protected. It has commercial value, and the person that sold it to Pepsi was under an obligation not to do that. So in that case, I could use the trade secret law in my country, which Bahrain has a good trade secret law, to go after that person and to collect damages from that person. However, let's say in a similar scenario, again, I work at Coke. I'm one of the people that has access to the recipe, and I put that recipe in my pocket. And I didn't do it on purpose. It was just, I thought it was something else, but I put something else in the safe, but took the recipe and put it in my pocket. Let's say then I'm on a flight. So let's say I'm flying back from UAE to Kuwait, and I accidentally drop that piece of paper out of my pocket and it lands on the seat next to me. Let's say the person that's sitting next to me finds that piece of paper, realizes it's the Coca-Cola secret formula, and then that person then sells it to Pepsi. Has there been any trade secret violation here? Well, again, what's the definition of it? It has a commercial advantage. It is not currently known, but did the person that sold it, that found those ingredients on my seat, did they do anything wrong? Did they have any legal obligation to protect that secret? No. So through accidental disclosure, what could have been a trade secret theft is now just an accidental disclosure, and it's unfortunate, but now that trade secret is out. So that's sort of what trade secret protection is. And again, a trade secret can be anything. It can be customer data. It can be an invention. It could be computer code. Again, anything that makes your company have a commercial advantage. And often, most companies, as their number one intellectual property asset, it's trade secrets. That's normally the number one thing that most companies have, especially startups. And then the last type of intellectual property, which we're really not going to talk about today, but I just want to list it, is data protection. So data protection is a very limited type of intellectual property. It's the data that a company submits to a regulatory body in the government that proves that the pharmaceutical product, the medical tool, or even the agricultural product is safe and effective. So I mean, the easy way to say this is it's like clinical trial data, because that's what it is. It's just data that a company has to put together in order to make sure that that product is safe, effective. That data is submitted to the government, and then the government then approves that product for marketing in the country. Question on this: can we say that data protection enters into the meaning of a patent? The data protection for the clinical trial data is actually quite unrelated to the patent. Whereas we'll take the example of a pharmaceutical invention. Let's say a new drug. So a new drug would be a composition of matter. So let's say that I'm a pharmaceutical company. I come up with a new drug today, and the new drug is a new composition. No one's ever done it before. I file a patent today. Well, normally it'll take you 2 to 3 years to go through the patent process. In most cases, most offices, sometimes longer. So by the time that patent is granted, let's say 3 years, which would be really nice. Now I have a patent to stop people from making, using, and selling that pharmaceutical invention. But can I actually sell that drug in the marketplace? No. In countries, you need to get approval from the health ministry, the drug ministry, in order to actually sell that drug in the marketplace. So in order to do that, I have to do these clinical trials to prove that this drug actually works. So often that takes many years. I wrote down here this is the term of protection, but often it can be 5, 7, 10 years to prove that drug does work safely and effectively. Currently, with COVID, it's actually been very fascinating to watch the speed of the clinical trials, given the severity of the issue and the priority of the issue. But all of that data that's being collected on the clinical trials, that is intellectual property, because it costs a lot of money and effort to do those clinical trials. Often, the cost of those trials can be tens, hundreds of millions of dollars. to prove that a drug is actually safe and effective. So it's a big part of intellectual property. For startups and entrepreneurs, it's not generally as important unless we are getting into the biopharmaceutical area. In that case, it would be very important because you wouldn't want to do all of this testing and protection and figure out that yes, your drug does work, and then having some other company that didn't have to put in all that effort to prove that their drug was safe and effective to get into the market instead of you. So that's why it's important to protect the clinical trial data that is used to prove that the pharmaceutical products or even the medical devices are safe and effective. So good question about the connection between patents and data protection. A couple more questions. That's great. First question is, in the example you gave on someone selling Coca-Cola's recipe to Pepsi, would Pepsi be legally required to not use the recipe? Great question. It depends. If Pepsi believes that the recipe was not used or was not taken in an illegal manner, then Pepsi can certainly take the ingredients, because the problem with trade secrets is that once the secret is disclosed, it's disclosed forever, and there's nothing really to do to put that secret back in the box. But if Pepsi knows that the trade secret was taken using theft or misappropriation, then there might be a duty of Pepsi to say, no, we are not taking that trade secret. We are not being a part of this transaction. And so it would be important for Pepsi to do some fact checking, some due diligence before they engage in really any type of transaction that could be seen as either promoting intellectual property theft or even helping it out. So, like, for example, if Pepsi went out and advertised, we will give everyone we'll give anyone $100,000 if they can go and steal Coca-Cola's recipe, then I think there'd be pretty good evidence to say that Pepsi was aiding and assisting in trade secret theft. But if, in the example of me leaving the recipe on the airline seat and some random person picking up that recipe and selling it to selling it to Pepsi, and Pepsi goes back and sees there's no connection to that person and Coke, there was no responsibility, that it was all an accident, yeah, I don't see much of a problem in Pepsi accepting that recipe. Good question on that. Next question. An example. I designed a chair so that someone in Italy also designed something like it, but mine is slightly different. I'm wondering how the government will accept my work as unique work, that I can register it properly. Not to mention, I created the idea by myself and didn't see the Italian work. Great question. So for inventions, it doesn't really matter if you have seen someone else's work or not. So if I am, I'm in UAE and I create we'll use a very simple example. I like to use pizza just as an easy way, because pizza has three elements: has a crust, has a sauce, and a cheese. And let's say that I'm in my kitchen one day, and again, it's the first pizza ever, and I invent a pizza today, and I file a patent application here in UAE. But then let's say that a person in Italy, the day after, also is in their kitchen and discovers pizza, but has no idea that I did this. then that person would file a patent application on their pizza. Well, 20, 30 years ago, there might be the chance that both those patents could be granted because there wasn't much communication between patent offices, and a lot of the applications weren't searchable. But nowadays, most IP offices have access to most patent applications that have been filed or published. So they can see what's been done. And because the process to get a patent takes several years, that generally the examiners within those offices will uncover those different inventions. So in this case, because I filed first, then I would generally get the patent over the person in Italy. But the question was something different. So let's say I invented the normal pizza. So 3 ingredients, crust, sauce, and cheese. But let's say that the person in Italy is something slightly different. So they added an ingredient. I love mushrooms on my pizza. So let's say that they added mushrooms on the pizza. So they invented a pizza that had crust, sauce, cheese, and now mushrooms. And again, to get a patent, the invention must be new. So no one had ever put mushrooms on a pizza before, so it meets that criteria. But is adding mushrooms onto a pizza, is that obvious or an inventive step? And let's say that no one had ever added mushrooms to anything like a pizza before, and it was brand new, and it was not obvious. So then, yes, because it was slightly different, but slightly different in an inventive way, then yes, the Italian person could get a patent on the mushroom pizza. Does that answer your question? For copyrights, it's different. So for copyrights, in the word copyright, it is copy. So there can actually be independent creation of the same thing, as long as the one person didn't actually copy it from someone else. And so for the copyrights, in the cases of infringement, one of the criteria that the copyright owner has to prove is that the person that they are accusing of copyright infringement had access to their work and had in some way copied their work based on that access. So let's say that I'm creating a poem about pizza. You can see how much I like pizza, that I'm talking about creating poems about pizza. Let's say I create a poem about pizza today, and the same person in Italy also writes the exact same poem about pizza tomorrow. But we've never talked about it before. We've never talked to each other. It's never been put on the internet, never been played on the radio. So there's no way for someone to copy either one. So in that case, both rights would be sort of there, and no one could say that the other person was copying me. But let's say that I had started to talk about my poem. I was putting my poem online, and we found out that the person in Italy had been listening to my podcasts where I had talked about my poem and then wrote his own poem that copied mine. That would be a pretty good example of the person had access to my work and then copied it. So that's sort of the difference between patents, where independent invention doesn't matter. It's the first person to invent. Whereas for copyright, there definitely has to be a copying involved. Great question. Next question. Thanks, by the way. These are great questions so far, and it really helps make sure that everyone is on the same page. Is there any legal issues if two companies have similar or exact trade secrets without actually knowing about it? Again, great question. Well, so are there any government issued rights that are associated with a trade secret? No. So like patents, you get the 20 years of protection from the government. Trademarks, it's also government right. Copyrights, government right. Industrial design, government issued right. Trade secrets, it's just you as the company have an idea, has commercial advantage, you protecting it, and if someone steals that idea, then there's a problem. But in this case, it's two separate companies have invented or created the same thing themselves. As long as one didn't steal it from the other person, then that type of independent creation or independent invention would be fine under trade secret law. And so, yeah, it would be perfectly fine. However, if, for example, let's say that company A, let's use Coca-Cola again as an example. Let's say Coca-Cola had an employee, and that employee left Coca-Cola, and that employee had access to the trade secret for the syrup. And that employee goes over to Pepsi, and in their line of work, sort of discloses the secret, but says, let's keep it a secret so no one actually knows. Then in that case, if it can be proven that the only way the secret got to Pepsi was through this theft, then yes, it'd be a problem. But if Pepsi and Coca-Cola independently come up with the same secret recipe and keep it secret for their entire time, no problem at all. Good question. Next question, can a trade secret like the Coca-Cola formula be further protected using a patent to prevent Pepsi from using it in case of an accidental leak? It's a great question to really talk about the difference between trade secrets and patents. So for patents, again, the government is giving you this really rare, limited right to prevent others from making, using, and selling your invention. But in order to do that, you have to disclose publicly your invention. That's the trade-off. So yes, so in this case, Coca-Cola could absolutely send their recipe to the patent office. Because the recipe is a composition of matter, it would fall into one of the four categories. If it's new, has never been done before, then yes, they could get a patent. But because they got a patent, they have to disclose what that invention is. So the requirements for disclosure of a patent is you must disclose the invention, whereas one person in that technology or art or that field knows how to make and use that invention. So Coca-Cola couldn't just say, I want a patent on my list of ingredients, but I'm not going to disclose the ingredients, because that's not what patents do. Patents are to disclose how to make and use the invention, and if you do that, we'll give you the 20 years of protection. So Coca-Cola could do that. They could file a patent, but once they file a patent, it's now public, and they've sort of lost their ability for trade secret protection. Why is this important to startups? Because deciding whether to keep something a secret or a patent is a big decision. Let's say that your invention or your competitive advantage is very difficult to figure out. And you believe that you can keep it a secret for more than 20 years. That not only is it hard to determine, but it would also be very hard for someone else to copy. So you say to yourself, well, if I disclose this and I get a patent, I only have protection for 20 years. But if I keep it a secret and I know that it's going to be hard for someone to reverse engineer, I think I can get more than 20 years of protection from this. Then you might decide to keep it a trade secret and not the patent. But, for example, which is often in many cases, if your competitive advantage or your inventions are easily discoverable and can easily be taken apart and learned how they are made, and trade secret protection would not be effective, then yes, you want to get a patent, because no matter if it's reverse engineered or if it's independently discovered, then you would still get your 20 years of protection with a patent. Whereas if you tried that with a trade secret and you risked it and that trade secret was disclosed immediately, now you've lost the ability to get a patent. Because again, a patent has to be new. And once a trade secret is disclosed, that idea, that invention is no longer new. Great questions. Well, last question was, I was asking about all the criteria that my idea would pass for a patent. Good question. So for a patent, again, for an idea, because we generally don't like talking about ideas as patents. It's generally you have to pass a few different requirements. One, the subject matter has to be patent eligible. So in this case, we have again, this is based on sort of US, but also global practice. A process is patent eligible. A machine is patent eligible. A article of manufacturer, patent eligible. Composition of matter, patent eligible. Things that generally are not patent eligible would be like just an idea of itself, or an algorithm, or a naturally occurring phenomenon, or even a natural product in nature. In some countries, they also include games or other types of ideas, or even some countries don't also protect sort of business methods, whereas you must have a technical element or technical feature within that disclosure, in that invention. So once you pass that requirement, the requirement of is this subject matter eligible for a patent, then you have to say, okay, well now is it new? So that's the next thing you have to pass. Then you have to pass the requirement of is this have an inventive step, or innovative, or obvious, so not just changing the nails to screws. So once you've passed those three requirements, then you have to pass the requirement of have you fully disclosed your invention in order for someone in your field of technology to make and use that invention. Because if you don't pass that last part, then why should the government give you rights? And then one of the last things you'd also have to pass is, have you defined your invention clearly? So have you made that boundary around your property clear? So if the boundary around your property is not clear, how does someone know what is your invention and what is not? So those are really the 5 key requirements to get a patent. So is it the right subject matter? So is it a machine, process, manufacturer, composition of matter? Is it new? Has it ever been done before? Is it inventive or not obvious? Have you disclosed it such that someone having ordinary skill in that technology can make and use that invention? And have you disclosed it in a way that's clear and is not ambiguous, or it's not definite, so it has clear boundaries? Those are generally the 5 key requirements that governments like to check before they'll give you those 20 years of protection from data filing for a patent. Great questions, guys. Thank you so much. So our last part we're going to do before we take a break is we're going to do a few exercises. So again, we had, let me make sure the slides are popping up since there's some graphics here. Might do this view easier. Okay, so our next few exercises, we're going to say, can you identify the intellectual property? So each company, each invention, each brand, each business often has many different pieces of intellectual property. So we said patents protect inventions, trademarks protect brands, copyrights protect creative works, industrial designs protect the ornamental features of an article of manufacture, and then trade secrets protect the commercial advantages that are not generally known. And then data protection is for clinical trials. So what we're going to do is I have 3 exercises for us. And what I want you guys to do is I'm going to pull up the exercise. It'll be a picture of a product, and you guys need to list every type of intellectual property protection that you see in that product. So please put your answers in the chat box, and I'll sort of run through as people are typing what's going on. So our first exercise is this. So this is Microsoft software. What type of intellectual property might be involved in this? And please identify if you're saying it's an invention, say what is the invention, or the trademark, what is the trademark? Any ideas? Okay, there's a logo. Someone says logo, but which logo? Trademark as the logo of different softwares. I like that. That's good because there's different logos for each of the different programs. Great answer. But what else? So some said copyright, but copyright of what? Copyright for the software, or the code. Perfect. Good. To differentiate between the code itself and the way it works. All right. The name of the company. Perfect. So Microsoft. Great. What about the little box next to the name Microsoft? The logo of the company. Awesome. Perfect. I mean, I think you guys have gotten most of it. So correct. So there's the trademark of the name, text name, Microsoft, and then there's the logo of the top corner, the square, like the red, green, blue, and orange box next to Microsoft. So those are each trademarks. What about the name, Office? Another trademark. And then someone also mentioned in the chat that you could trademark each of the logos of the different types of applications. So Excel, Notebook, or OneNote, Outlook, Word, PowerPoint. Yep. Each of those can be trademarked. And then you also have the different, at the bottom of the box, the Windows logos in different colors and different styles. So each of those could be a logo and trademarked. And then exactly, someone mentioned the software, what actually is inside the box. Perfect. Why is it important for us to identify each of these? Well, what if someone what if you only had one? What if you'd only protected one brand? Well, then someone could then steal all your other brands and put it on their products. And as long as they didn't put the word Microsoft, then they'd be fine. But when you identify that this product, we all sort of know what the Microsoft apps look like because we've been using them for a while. So even though it doesn't even have the word Microsoft on this box, we as consumers would be confused. And so it's important for us to protect anything that you believe identifies consumers to your product. Question. Would there be a patent for the applications or softwares themselves? Great question. So patents can protect a process. So can that protect, let's say, the function of Microsoft Word? So, I mean, there is a process going on. I mean, there is software code that you download from Microsoft, and that software code implements different pieces of hardware within the computer and even on the screen to implement the features of you typing letters on your keyboard, those keyboard letters going into some processing thing, and then being transmitted to a visual depiction of those words in a manner in which you had typed them. So you're using both software and hardware to conduct a method. So yeah, I think if you draft the patent correctly and you talk about the interaction between the hardware, the inputs, the outputs, that yeah, there is a method there that could be patented. The question is, in this case, can it be patented because has the idea of typing words on a computer then onto a screen, has that been invented by Microsoft? The answer to that is no. I mean, there's been different, I mean, since the beginning of computers, when you would type on the keyboard and the letters would pop up on the screen, I mean, that uses software to do that. So really what Microsoft is protecting is the look and feel, the connectivity, and some of the functions that Microsoft might have, but the basis of typing on your keyboard and coming out on the screen, that would not be new. But as the question asked, can the application software themselves be patented? They can if it, again, involves sort of technical features and function that you could say is a process. So yes, great question. All right, next example. So we have Johnson & Johnson's Baby Naturals Nourishing Lotion. What are the different types of intellectual property in this product? So it says the logo, the method of synthesis, so that's the method of making the lotion. I like that. That's a method. We patented. I like it. What else? The brand for the trademark. Ooh, a patent on the formula. So not just the method of making it, but also the formula itself. Great. Ooh, someone even said data protection for the trials done before selling. I like that. I think you're going for data protection about has there been clinical trials that prove that this lotion is nourishing, is safe for babies. Perfect. I like that. What else? So there's a few different trademarks in here, so we won't get into that too deeply, but there's one thing that we're missing. So we have the logos, we have the trademarks, we have the patents for the composition of the formula. We have a patent for making it. What are we missing? So the lotion is in what? It's in a container. Are all containers the same shape? Industrial design, thank you, perfect. So industrial designs protect the ornamental features of an article of manufacture. So in this case, the article of manufacture is the shape of the container that this product is in. It's not just the shape of the white part, but also the shape of the top part, either separately or in combination, especially if it's new. So when you're walking down the store and you see all the other types of lotion for babies, they're all in different types of containers, mostly. But this one might stand out because of the ornamentation of the container itself, not just for how it works. Great job, everyone. That was really good. All right, and for our last example, from Bahrain in particular, what are the different types of intellectual property in this technology in this invention. So this is the app where you can get together with friends and register to play football in different stadiums based on availability, based on maybe skill of yourself. And so what types of intellectual property might be part of this one? Industrial design, I like it because it could be the graphical user interface. We talked about that earlier, that right now the designs in the digital age can be protected by graphical interface. Dr. Edwards says we had the co-founder our day talk about it. Perfect. Patent on their idea for the app for the football matches is unique because it hasn't been done before. The code, good code be done by the copyright, trademark for the logo, and the application design. Perfect. So I think you're seeing very quickly that just because someone has one idea, that there can be many different pieces of intellectual property as part of that. And so, but part of customer data, perfect. I like someone said that. So the collection of the customer data can create value. Excellent idea. So the next slide I'm going to share is something that actually Dr. Ezra and I and the team did a few weeks ago, which was, so part of what we like to do is when a company or startup comes to us, we want to sit down with them and go through all of the pieces of intellectual property that company or startup might have to identify what type of IP they have, what's the highest priority to protect, and how to protect it. So we call this IP capture. And so this was it's a little bit small for everyone to read, but this is the exercise that we did a few weeks ago, and going through and identifying all the different pieces of intellectual property from this invention. So we talked about the name in Arabic text, the name in English text, the logos, the colors, the computer code, even the website URL, the design of the application, and then how the thing functioned. And we sort of listed all the pieces of intellectual property on one side, how we would protect it, and then what would be the priority in protecting that for that company, depending on what was new, what was easy to copy, etc. So this is a real sort of world example of ways where you can take your company and start identifying all the pieces of intellectual property. Let me go back. So I have one more slide before we take a break. But let me go back to a question that I missed on the software. The question was, it's common to use cracked software. What about it? How a company like Microsoft, for example, gets their rights if individual users out there are cracked software. Yeah, so this is all about software piracy. It's bad. I'll start with that. I mean, it's essentially theft. It's essentially that a user that uses cracked or unlicensed software is not paying for the use of the legitimate software. So it'd be the same thing as if if a person copied a piece of music or a movie and then either allowed people to have access to that online or gave it to people using physical discs or on USB drives. So it's something that all of our software companies don't want to happen, because if people start stealing the software, cracking it, and then giving out unlicensed, then that money can't go back to the software company to make more improvements to the software. I mean, think about it for Microsoft. People say, oh, well, it's a big company. They're not they lose a little bit here or there. Think about the first version of Microsoft Word or the first version of Microsoft Office compared to today's. I mean, the only reason that Microsoft has been able to keep updating these applications to make them even more usable is because people have purchased legitimate versions, and they keep investing that money to create new rights. That's just Microsoft. Think about if you're a startup and you create a new application or new software, and it's just sort of recognized that, okay, it's going to be stolen or cracked, and the person that put all that time and investment into it is not going to get any investment out of it to make new software or improve their designs. So what happens, you now just have crappy software that won't be improved. And you also have software designers that say, well, it's not worth it my time to even create new software at all. I'm going to go do something else. And you start to limit the amount of good software, good programs, or good ideas out there. If that sort of idea that it's okay to crack or to download free software that's been pirated is okay. So it's a great point that you brought it up. I really appreciate that. I think that goes into more of the, as startups, as entrepreneurs, one of your biggest concerns is to make sure that people respect your rights. So how do you prove that you also respect other people's rights? So I have one more slide, and then we'll do a photo break for the cameras. But the last slide is to talk about about value. And often we talk about how inventions and patents are the most important part of intellectual property, the most valuable. I mean, I can show you data from the US and the EU that shows that I think over 35 or even 45% of generated from intellectual property intensive industries is from trademarks, whereas patents I think was between 15 to 8%. So I just want to really highlight that patents are not the most valuable. And the example I like to give is on cars. So the Aston Martin is one of my favorite cars in the world. I think it's just beautiful. But the question I ask is, are technical innovations, so patents, the most important? And when you look at the Aston Martin is not the fastest car. It is not the most reliable car. It costs a lot to fix. It doesn't have the coolest electronics or coolest gadgets in it. But yet it's still very valuable. And why is that? Well, it's the design. It's the quality of the manufacturer being hand-built. It's the reputation of the car, but it's also this car was connected with a creative work, the James Bond movie series, and even in the books also. So this brand is valuable, but it's not valuable because of the technology. And I say this because I've been in the region again for about 2.5 years, almost 3 now, and I've gone to some incubators around the region, and they'll often come in and say, hey, look, Pete, can you come and talk to our startups and in our companies that have these really cool technologies? And they say, I will, but I want to talk to everybody, because everybody's intellectual property is so important to protect and to grow and to create businesses, not just the ones that have a new technical invention. So for everyone out there that thinks that your IP is not as important as, say, the new camera invention we were talking about earlier, or a new medical device, that brands and creative works drive economies and are so critical. And I just want to sort of end that with, in today's first half, with saying every type of intellectual property is important and has value. So we think about that. And therefore, when we sit down and we go out and we list every single piece of intellectual property they have, we often find that there's more important competitive advantages or intellectual property to protect that might be easier to protect and cheaper to protect than, say, the technological innovation. But in order to make that determination of what to protect, you have to identify every single piece of IP first. Because in order to prioritize or pick out what IP you're going to protect, you must know what you're playing with. What list of IP do you have? So how do we do that? We first, again, we want to talk to the company, startup, and go through and say, what are all of your pieces of competitive advantage? So these are the questions I like to ask. Why did you pursue your startup? What problem was solved? Who are the customers? And then sometimes it's important to make sure that the startup actually has customers for the product. But you ask these questions because these really determine why the startup thinks that their company is going to be competitive in the marketplace. And once you determine why they think that, then we can say, well, we want to make sure that we protect that. So, for example, I'll use Apple just as the example for most of today's discussions. And so, originally, Apple wanted to make, we used Apple phone as an example. So the Apple phone was, we want to really transition from that flip phone to something else. And so why do we pursue that? Because we wanted to create a higher quality phone that had a more seamless interface. So for Apple, why did you pursue these phones? Well, again, to compete, but also to create a better design, higher quality. So quality is important, design is important. Are Apple phones, do they have the best technology, the fastest processors, the best cameras? Often they don't, but it's the platform, it's the look and feel, it's the quality of the features that make it something that you might want to buy. So once you start identifying those, then you can start listing out, well, for the iPhone, we might want to protect the shape of it, the graphical user interface, maybe some technology inside of it, and then that sort of starts to become that list. We also want to look at our competition to see who is our competition out there, and why is our company competitive against that competition? So when we identify what's different, then that's what we want to start protecting. So if you say, well, our phones, they have a better landscape of all the different icons on the screen versus the competition that doesn't have that. So that difference means we want to protect that competitive advantage. So we want to protect the graphical user interface of the way that our icons are laid out. How else can you identify your competitive advantage? Well, you need to know, is something new? If you want to get a patent, for example. But often it's difficult to know, is this new or not? And so I've often had startups come to me and say, hey, Pete, we just created this. I'm trying to think of something recent that happened. It was a small type of a vehicle that a company, I think it was in Tunisia, had designed that would make transportation of certain goods easier. And they said, like, we want to get a patent on this new vehicle. I said, okay, well, how do you know if it's new or not? Because if it's new, then that would be in a competitive advantage you'd want to identify and protect. And they said, well, we haven't seen one like this in our city. And then we talked to our friends in some other cities in the country and also didn't see anything like that. And we also had friends in incubators in other countries, in North Africa. I was like, that's good, but if to be new, to get a patent, it needs to be new globally. So I suggest going out and making sure you identify whether this is new or not, to identify whether this is a competitive advantage globally, or more regionally. And so that was also important. And I like the second bullet here about who do you trust to tell you it's new. Um, One of the first cases I ever worked on was about 16 years ago in the U.S. And I had this startup come to me with a very simple mechanical device. Um, and I asked, well, how do you know it's new? And they're like, our parents told us it was new and had never seen it before ever. I was like, well, I'm glad that your parents have faith in you that this is a cool idea, but you need to make sure that if you're going to invest, say, often what it costs to get a patent, which can be 10,000 US dollars, do you trust that what you've made is new and that that investment in getting the patent protection is going to pay out? And it turned out that we did a quick search online and found out that no, their little mechanical device had been done before. So making sure that you are aware that depending on what's a competitive advantage could be based on someone's opinion. So making sure that you have a trusted opinion in order to tell you whether this is new and should be protected. Next thing to do is identify what's your biggest risk. This is a great example for Apple again. So looking at all of your pieces of intellectual property, be it the technology, maybe it's industry know-how, so trade secrets, maybe it's your logo, the quality, even the people that you hire in the creative works. What's your biggest risk if you lose it? And I think that's something that every startup, every entrepreneur on this call should quickly start identifying. What's the one thing where if you lose it, you have pretty much lost the ability to enter the market and you've lost your competitive advantage? So the example we'll use again is for Apple. Let's say that Apple creates the new camera that we talked about earlier, because they've seen that their cameras, the other people have better cameras. So they invest, let's say, $3 million in developing new camera technology, and then $5 million in creating the actual cameras, and then $12 million US to put it into their phones. So they've invested 20 million US dollars in creating these new cameras that are top of the line. Let's say that they forgot to protect the camera and they did not file a patent application or get patent rights on it. So that means that someone could reverse engineer the cameras when they were sold and could quickly determine how Apple made this cool camera, and then they use that knowledge to put the cameras in Apple's competitive products. That sucks. I mean, Apple just invested $20 million to create these new cameras that they thought would give them a good competitive advantage. So that seems bad that they've lost $20 million in investment because they didn't protect their competitive advantage. However, let's say that Apple forgot to renew their trademark rights. So let's say that in that same country that Apple forgot to patent the phone technology, they didn't see that their trademark registration was about to lapse after 10 years, and they had to renew it, and they forgot. Let's say a competitor realized they forgot to renew their trademark registration and jumped in the day after it expires and registers the Apple logo and the name Apple for themselves. And let's say that market is the US. Now what's happened is that Apple has lost the ability to not only protect this name of Apple, the logo, and the name, but now another company can legally stop Apple from using its brand in the US. What's the damage to Apple for not protecting its trademark. It's probably a lot more than $20 million. It's the entire brand of all the Apple products. And it could prevent Apple from even importing any product into the US that had that Apple logo on it, because now someone else owns it because they forgot to renew the registration. So I mention this because often companies will say, well, if I lose my technology, I've lost everything. But often it's the brands that a company has developed over years and years and years of effort to show that people, when they see that logo, see the name of the company, have this reputation that this product is going to be great. And if they lose the technology, you know what, fine. I mean, Apple can recover $20 million. It might take them some time, but if Apple loses their logo and their brand, halas, it's over. So when you're done with today's discussion, think about what is the one thing that if you lost, it would be very hard to come back from. And this could even be people. You might have an amazing business partner or a software developer that you know your company would be lost if this person left. So in that case, the people you have in your company, that has an economic value and you want to keep them there. So make sure you protect what is your greatest competitive advantage. All right, we have our first question of the second half. Thank you so much. The question is there an international database for all registered patents? The easy answer is no, but there are some databases that do have most of the patents out there. The patent offices in the US, the EU, Japan, Korea, and China account for approximately 90% of all granted patents. And all of those patents and published applications can be found online. The best place to look for them, I would suggest, is the World IP Organization has a patent searching database that not only has access to all 5 of those patent databases, but also has many other offices as well. So that's probably the best place to look for those applications. And this sort of goes to another good point, is just like with land, that the property rights are within that country that the land is at. So if you have a property right in Bahrain, you don't have rights to a similar property in another country. You have to go to the other country and get rights there. And it's the same thing with patents, with trademarks, with industrial designs, is that you have to register and get rights in each of those countries if you want to protect your intellectual property there. So for example, if you are in Bahrain and you get a Bahrain patent, that patent stops anyone in Bahrain from making, using, selling, or importing that invention into Bahrain. But if someone makes that invention across the border in Saudi Arabia, your Bahrain patent doesn't have any force. However, there's good news for at least the Gulf countries, is that there is a Gulf Cooperation Council Patent Office, the GCC Patent Office in Riyadh, where if you file one GCC patent application and it's granted, you have rights in all 6 countries. Unfortunately, there is no such GCC trademark office, so you'd also have to get trademark rights in every single country that you'd want. There are international treaties that make this process easier for many countries, and that would be something you'd want to dive in a bit more with your expert IP attorney later on down the process. There are some other good databases while we're talking about databases. There's a database called Trademark View, or TM View, and also Design View. Both of these are very good databases for global trademark rights and global design rights around the world. But again, make sure that they're different for each country. these are great databases. Let me write it out quickly in the chat box. So TM view and design view. Good question. So again, when you identify competitive advantage, again, what's the biggest risk? If you lose it, make sure you protect that first. All right, questions about any more questions about identifying what your best competitive advantages are? It's sort of what we did in the exercises. Look at your business plan, look at your company, go through and identify every single piece of intellectual property, be it the brand, the logo, the name of your company, the software code, the design, the graphical user interface. List them out and figure out which one is most important. So now that we've identified it, we want to make sure that we now protect. So protect the competitive advantage, protect the IP, and the first thing you want to protect it from is losing your rights. So with patents specifically, and also with industrial designs, the requirement is that, or one of the requirements, as we mentioned in the first half, was it must be new. That the invention must be new, the industrial design must be new. How do you make things not new? You publish them. So unfortunately, what we see in many startup communities is that there's a lot of encouragement to disclose what your startup is, what your inventions are, what your business models are, and to talk about it with other startups, talk about it with investors. And unfortunately, types of publication can make it impossible for you to get patent rights or industrial design rights, because once you publicize something, it's no longer new, and that defeats one of the key requirements of a patent or industrial design. Thankfully, certain countries, including Bahrain, put in place what's called a grace period that says that if I disclose the invention publicly, I have 1 year to file patent rights, and I won't lose the ability to get a patent. So meaning that if I disclose my invention to someone today, I have until a year from tomorrow, or a year from yesterday, to file a patent application and still be able to get a patent. However, this rule does not apply to, say, Europe. So if you disclose your invention today in Bahrain, you have 1 year to get file a patent in the Bahrain Patent Office, or even in the US, or in Japan, and I think Korea now also. But once you publish it in Bahrain, you have most likely lost the ability to get a patent in the European Union, which is unfortunate. And there are many other countries in this region that also don't have grace period protection, and say that once you disclose your invention, you have no ability to get a patent on that. So it's a very critical thing for startups and entrepreneurs to realize that by disclosing rights, you might have lost the ability to get a patent on that. So that's probably one of the most important things coming out of this discussion, I'd say, is make sure you're very careful about disclosing rights, but also how much you disclose. Because if you just say to me, Pete, I have this idea about, let's say, this new camera, and I said, that's really cool, that type of disclosure is probably not enough. But if you had sat down in a, let's say, a public workshop, and you had described how your new camera works, how it functions, so that one of ordinary skill in that technology would know how to make and use that invention, that disclosure is probably enough to say that it is no longer new. So it's something to be very aware of, and especially as we're looking at global markets, making sure you know which markets have this type of grace period protection and which ones don't. because that will determine when you publish, and how you talk to other people about your inventions. Questions about disclosure and losing rights. This is a very important topic. Well, if there are any questions about this, please let me know, because this is something that will affect most startups sometime in their lifestyle. All right, we have a question about trademarks. May I ask, what's the point of registering the same logo or name on a regular basis, assuming the company doesn't wish to change anything? I mean, the way you put it, tremendous losses may occur if the company forgets or someone else beats into the registration. Great question. So why do we not just say you can have a trademark forever? Well, it's about market access, and it's about opportunities for other people. So if we say that if I trademark, let's say, Apple forever, now I've taken the trademark sort of off the potential for anyone else to use Apple or the Apple logo for anything related to electronics, for example. But let's say that the Apple company had stopped functioning 20, 30 years ago, but those trademark rights are still enforced because in our imaginary country, we're giving trademark rights forever. Well, if no one's using the logo or the mark, then does it make sense to keep it protected? Or would we rather have that logo or mark be available to other people that might want to use that to identify their goods or service? So that's why we put in place measures to make sure that companies are using their logos in order for them to get protection. Else it's sort of this forever long monopoly against other people using that name or logo without having to use a name or logo. And actually in most countries, at some point you actually have to prove that you're using the mark. So in the US, we're a bit different, where in the US you can only get a trademark if you prove that you are using the mark in commerce. In most countries, you can get a trademark without showing actual use, but after a certain number of years, generally 3 to 5 years, that other people can file opposition proceedings against your trademark if you're not using that mark in commerce. So again, the trademarks are really about not the products themselves. So they're not just identifying those products with a company. So that's sort of the policy reasons why we want to encourage people to use these marks and to make sure that they renew it. And yes, it is a challenge, but most companies that have lots of marks have representatives that their job is just to monitor and maintain all their trademark registrations around the world. So think, for example, FIFA or even Apple. I mean, they are protecting their mark probably in every single country in the world, and they're generally able to do it. But it's a priority that they put there. It's a priority that they invest money to make sure that their investment is protected. And so that's sort of why, is that if people aren't going to use their trademark, then it should go back to the sort of public good for someone else to use. Good question. All right, so we've talked about protection from loss of rights. Another way that you can also lose rights is if you don't enforce the rights you have. So if you have, let's say, a patent or you have a trademark, let's use trademark, for example, and you have the rights to trademark, but you're not taking any actions about other people using your trademark rights. So people are using your mark for other goods, other services, and you're not really enforcing your rights against it. And let's say that goes on for 10 years. And now someone comes along and uses your mark, but you don't want that person to use your mark. The person that's not using your mark might have a argument that says, well, you as the company have never demonstrated you're actually enforcing these rights. Therefore, they're now gone to the public. and therefore you've lost the right to enforce. So that can happen based on the laws of your country. So something also to be aware of. What else do you have to protect your IP and competitive advantage from? Well, the question is, I mean, who are you protecting it generally from? You're for your competition. So in what ways can you protect your intellectual property from the competition? So we talked about earlier in the day about the patents. I mean, again, that can protect the invention, especially if it's easy to disclose. But sometimes, do you actually need to protect your competitive advantage at all? Do you need to have an IP protection around it? I think one good example right now is on the biotech industry, where to create a biotech product, the amount of investments and of capital needed to purchase all the specialized equipment to create a biologic type of medicine is expensive. Do those companies sort of have to worry that someone in their garage tomorrow is going to come around and steal it? No. But in the last few years, now we actually have companies that are creating biotech manufacturing processes that do make it easier to copy biotech inventions today. Whereas 10 years ago, you might not have had to protect your biotech inventions as much because it was just difficult to copy, and that the standard that people were currently developing in was quite low compared to some of the high-tech people. I had a chip company that was like manufacturing like a top-of-the-line chips, and I asked them, well, how are you protecting your technology? And they said, well, we have a few patents, but honestly, the amount of money someone that want to copy it would need to invest it'd be stupid for them to do it. So we generally don't, because the cost to copy it was more than the cost to protect it. If that makes sense. And it's the same thing when it comes to trade secrets. If you can keep your competitive advantage secret for more than 20 years, it's a patent, and it's cheap to keep it a secret, it's hard to reverse engineer it. Why would you then want to get a patent that would only be good for 20 years and would cost potentially a lot of money? So these are things of, can you protect it, and do you need to protect it? So when you first identify what is the most important competitive advantage for your company, can you even protect it? Maybe it's not one of the protectable things for a patent. Maybe it's not a method, machine, manufacturer, composition matter. So maybe you can't even protect it. And then do you need to protect it in the first place? Another good question is, how long is your protection going to last? And where do you want to protect it? Because if your market keeps changing, and for example, if your goods and the technology advances so quickly, does it make sense to protect the invention as it is currently today? Or if you have to keep inventing every couple of years to stay ahead of the market, then how do you protect that if you want to actually be using what you're doing now later on? And then similarly, where do you protect it? Because we said that IP rights are territorial, meaning your patent in Bahrain only protects you in Bahrain and not Saudi Arabia. So looking to where you can protect versus today's market versus your market in the next 10 years is very important as well. So these are more considerations to talk about when you're talking about protecting your intellectual property. And then protecting it from what also, here's the ownership issues. So ownership in intellectual property is extremely important, especially for startups particularly. As you're developing the cornerstones of what your new company will be, every single piece of those intellectual properties will have a specific owner or owners. And if ownership is not clear, in the initial part of the company, rest assured it is not going to be clear later on. And I've personally seen so many examples of where there was an initial startup that had, let's say, 3 friends that were just so excited about creating a new company, and everything was going to be great, and they were living out their dreams, and it was going to be incredible. And they created this company that had a brand, it had code, they got a few patents, and then all of a sudden, one of the members of the company found something better to do, or maybe their partner or spouse wanted to move across the world, and they had to leave the company. And now they started how to deal with, how do you break up this company? What does the ownership look like? And because the company had not dealt with ownership issues when the company started, it was honestly a mess of dealing with it later on. So number one thing I would just mention for ownership, make sure when you're starting your startup or you're starting to create intellectual property, that ownership of the intellectual property is clear. It's also probably advisable that ownership is as simple as possible. Once you have different entities owning the same thing, that makes breaking apart the company or people leaving, people joining, very, very, very difficult. Also think about work that you're contracting out. So if you are hiring a software company to develop code, make sure you're very clear about who owns that code when it's done. If you're contracting out someone to create the designs for your graphical user interface, make sure somewhere in the agreement there's a provision that says that you, as the owner of the company that's purchasing this design from another company, you own that intellectual property and all of it. And again, I think this is one of probably of all the IP issues that companies have, they normally come back to ownership. So it's not hard to fix, but it's hard to fix if it's not done right initially. So be very, very clear about who owns what and what happens when people join or leave. Another thing that I often see, again, for sort of internal factors that can really hurt a company, especially initially, is when they say, well, we don't have enough money to protect our intellectual property. And you know what? Money is a huge part about startups, entrepreneurs, especially in the initial phases. And there's no way that a startup is going to be able to protect all of their IP in the way that a larger company might want to. But the fact that I've heard this at least once a month for my entire 16, 17 year doing IP, is companies say, well, we had other things we wanted to invest in than protecting our IP. And I say to them, okay, well, how long have you invested in creating the company to where you are now? How much money have you spent to get where you are? How much education have you gone through to be in a position to create the intellectual property that you're doing? And often the amounts of money that they're saying are hundreds of thousands of dollars, if not more, 6-7 years of training and experience. And then they come to me or to us for advisement now and say, well, we don't want to pay the $5,000 to file these trademarks in this region. And I look at them and say, like, look, if you clearly value your company, you've invested all this time and effort into it, but you're not going to value protecting it. And that often is what changes the discussion when they tell themselves, here's everything I've already invested in this, and if I lose it, it's all gone, versus investing a small percentage of what they've already invested in the company to protecting that company. And I like to use, going back to my favorite example of land. So you are walking down this street again, and you see an empty plot of land, and it's massive. And you know that in 10, 15 years, it's going to be next to a popular road in a popular neighborhood, and the value of this could be incredible. But you only have a limited amount of money. So what you decide to do is you decide to take a shortcut. And instead of hiring a company that's going to come and do a survey of the property and generate one of those fancy, detailed sketches of what your property is, using all the laser technology, maybe GPS sort of like identifiers to show the exact border of it, you decide that you're going to take a 2-hour course online about being a surveyor, and you're going to go out to the land with a long piece of rope and maybe a compass, and you're going to create your own survey. Well, you've saved some money. That's great. And down the road, yes, everything works out, and your land gets all this value. It's next to a big road. It's in a great neighborhood, and someone wants to come buy it. So they come to you and say, like, look, we want to buy your company. And they say, well, we want to see what the property is. What's the legal bounds of your property that you're going to sell us for all this money? And you hand over this document that you created yourself, and the company looks at you and laughs and says, this isn't going to be legally enforceable. There's nothing. This is all wrong. You've used the wrong values. You're missing this documentation. This hasn't been signed off by the right people. You're missing this stamp over here. And the company says, okay, well, thanks. We're not going to buy this from you. And you're sad. You've lost out on a big deal. Next day, that company now goes and files a dispute against your ownership rights to that property. And it goes into court, and the court says, well, yeah, this deed that I had created 10 years ago is crap, and it's not good, and therefore it has no legal right, and this big other company can come in and take it from me without paying me. This scenario happens all the time when it comes to intellectual property rights, especially patents. I see it over and over again where startups or inventors try to save a little bit of money and try to do it themselves. And then when they eventually try to sell their company or get new investors to come in, those investors will look at the intellectual property rights that you have and say, look, this is good. We're going to come buy your company, or oh, this is not good, and we can find many holes around it and don't have to work with this company. I see it all the time. I think the land example is a good way to describe that. If you're going to invest in something, put your time and effort into it, make sure to put your time and effort into protecting it as well. Because I see it over and over again where shortcuts are done on the early side and the long-term impact is huge. Costs. Again, these are all factors that startups or companies will have to factor in. So the cost to protect, so the cost for a patent just for filing are generally about $10,000 US, often more. And then there's different filings to maintain protection, so renewing trademarks. There's costs to enforce the rights and not to enforce the rights. But again, the way that you're going to decide whether and how to protect your rights is think about what's the cost if you lose the intellectual property in the first place. So if the cost to protect is more than the cost, then you're going to lose it, then you might not need to protect it. But if the cost to protect your rights is less than the cost that if you lost those rights in the first place, then you definitely want to protect your rights. So patents are generally the most expensive type to get. And then designs, trademarks, and copyrights are much cheaper. So identifying every single piece of your intellectual property first, and then identifying what's the cost to protect this will help you prioritize which to protect and which that maybe you can wait to protect later on without risking too much. And then sort of the last sort of topic for today is about perception. And I mentioned this very, very early on in today's discussion about people that have ideas or people that have assets. And I always like to say that everyone has ideas, but not everyone has an asset. So it's really all about perception. So for startups, perception matters. Your goal is to separate yourself from other startups, not just in Bahrain, but in the region and globally. And you have to prove yourself to those initial investors to when you want to scale up, you need new investors, or when you want to exit or create a permanent company. Each of these different parts of the startup life cycle, and there are more different steps within this, you need to convince people that not only is your company have a good idea, but you're serious and you have something that the investor can take or grab or touch that shows the value. And ideas, you can't touch an idea, but you can touch a piece of intellectual property when it's protected and it has a government right established with it. So this is why having an asset versus just an idea is super critical when it comes to making sure that your startup stands out. Even if even that IP, the value is quite low, the fact that you have identified what your competitive advantage is and you've secured legal protection, that's something that people want to see as a way that shows that this company is serious what they're doing and could have potential later on. I've seen examples with companies that have probably a better idea than another company, but the company with the less exciting idea has a portfolio of intellectual property assets. I've seen the majority of times that they'll go to the company that has has not the best idea, but has actual assets in it, because the investor knows that's a safer place to put their money. Another part of perception is with the governments. Even in lots of governments in the region, including Bahrain, are looking to support startups and entrepreneurs. But not everyone can be supported. It's only, again, limited amount of money, limited amount of time. So how does the government choose which startup they're willing to support? I've found again, over and over again, that if a startup can show that they have intellectual property assets, not just ideas, that they have a bigger chance of being selected for government startup or entrepreneur programs over and over again. Again, it's about the perception of an idea versus an asset. And then other types of perception, customers. If you are going out with your company or brand and you have registered your trademark and you put the little like R logo or TM logo next to your brand name versus another company out there that doesn't have that, there's a visual perception immediately that the company that has trademark protection is more serious. It might be around for a longer period of time. The customer is buying some technology that they're looking at the brand, is like, is this brand going to stay around for a while? Because I want to use this technology not just for a year, but down the road as I integrate it into my systems. If they see that the company had protected their trademark, the customer might say, okay, look, they're going to be around for a long time because they put value in investing and protecting their brand. Therefore, I might be more willing to pay for that service or technology because they're going to be around for a while. But if they haven't protected their brand, then do I trust them that they'll be here next month or the year after? Maybe not as much. And then sort of maybe one other type of perception that is sort of being developed sort of globally right now is with banks and financial institutions that are willing to give small business loans based on IP. So often, right? I mean, often loans are given based on collateral, have to demonstrate either a down payment or property, like a real piece of property that you could give to the bank as collateral for your loan. We have seen for many years that intellectual property can be used with banks as a form of collateral to get loans. But often these are large patent portfolios. But more often we're seeing sort of a nuanced approach where startups can start to look for banks and give them collateral in their IP and get small business loans. So it's something that's starting out sort of generally, but it's something to think about if you're trying to get a loan from a bank and say, you're telling the bank, look, I have a good business plan. That's one thing. But if you're going to the bank and saying, look, I have a business plan, I have 2 patents, 3 trademarks, I have 6 copyrights, and I'm willing to give you, the bank, an interest in these pieces of property if I default on the loan. Do you think the bank is more or less willing to give you a loan than, say, if I would go into the bank and say, hey, bank, I have a really cool idea. Here's my business plan on paper. You should give me a loan. I think the bank would feel much safer investing in the company that actually has a legal asset. And then finally, perception, competitors' perception. Again, I mentioned early on today that competitors are out there. And these are good competitors, but they're bad competitors that just want to copy something and make it quick money. If you, as a company, look like you are protecting your intellectual property through intellectual property rights, you have the little trademark trademark logo next to your name, you have patents, you have a list of all your IP assets, do you think that your company is more or less likely to be a target of a bad actor? It's the same thing goes when you're looking for investors. So the last one again is about protecting yourself against others. And so for a startup, you're looking for investors. And if you're going to investor, and one of the biggest worries I hear from startups is we don't want to actually disclose our inventions or our business plan too much because we're worried that an investor or a big company is going to take it and copy it and not pay us. Huge concern, huge worry, and something that most startups think about. How do you make yourself not a target? You make yourself not a target by making the perception of your company that you have taken steps to protect your intellectual property. So if you're going to investor briefing and you say, look, we have filed 3 patents, we have copyrighted all of our code, we have copyrights on our designs, we've filed for a graphical user interface protection for industrial design, we have 2 trademarks, and we have a list of trade secrets that we're not going to share with you today, but we have a list of them. Do you think that the investor you're going to sort of pitch your idea with is going to think that you might be a good company to try to take advantage of? Versus, let's say I go to that same investor, and just like with the bank, I say, here, investor, here's my idea, here's my business plan on a piece of paper. What do you think? Well, if I'm the investor and I'm sort of a bad actor, I will definitely look at that second person that had no IP protection as maybe a very good target to try to steal something from. So perception matters a lot, not just for the startup life cycle, but for customers, for governments, and even competitors. So I think it's why it's not just important that you have the IP, but what it actually does for you. So then I think we're almost done. When should the idea be an asset? And these are business ideas that you're going to have to look at and decide, do you want to publish? Do you want to sell it? Do you want to improve it? How do you protect it, and when do you protect it? How do you protect your brands? How do you protect your designs and your content? And then once you have these intellectual property rights, I mean, they can just sit there. But like with your land, you want to use it. So you can use it to seek financing, as we mentioned. You can sell it. You can license it to people. So you can rent it either exclusively, so only one person can use your IP, or you can rent it to as many people that want to use it, like you would for creative content. You can promote your rights. So with the investors, you can go and say, look, these are the legal rights I have, and I'm not worried anymore because I've protected them, but I'm willing to license them or sell them, or here's why I'd be more competitive than someone else. And then finally, you can enforce your rights. You can stop other people from stealing or trespassing on your rights. But until you actually have legal title to your intellectual property, you really can't do any of these. It's just still an idea. So I think that's where we're going to end for today, is just the final thoughts again. If you're a startup, number one, identify your competitive advantage. Then protect it and make sure that you've identified what's the one thing that if you lost, you could really not recover from. Once you identify that, then you can protect it. But until you identify all of your pieces of competitive advantage, all your piece of intellectual property, you might actually miss what's the most important one, like we saw with the Apple logo versus the Apple camera. Once you've done that, you've converted your ideas into assets, you've made your perception more positive, then you can start using your rights and using your assets in the marketplace to really grow and make your company successful. So I will end there and be open for any questions as well. But yeah, I mean, I think we've gone through and sort of seen the whole landscape of what is intellectual property, how does it impact your companies, and why it's important for you.
Thank you, Pete. Thank you for this comprehensive, and I'm sure that so many questions have been answered. Students have been maybe skeptical about a few things, and you clarified all of these issues for them. Guys, if you have any more questions for Pete, you could also ask about, reflect on your own, let's say, work that you are doing right now. And like Pete said, that you should be thinking about what is the most important thing that will make your organization either stay or perish. So again, and how are you going to protect this and make sure that you have this competitive advantage and not to lose it by, it could be a very simple thing that you need to do in order to protect your company, let's say. No questions? Done? It's going to be overwhelmed, I guess. Maybe they do a little bit more thinking for what the future directions for their projects are. Well, thank you so much, Pete. Really appreciate the effort. Appreciate all the details that you provided with today. I've already recorded the session, so if it's fine with you, Pete, I will be posting these on our social media. If not, please let me know.
All good.
Okay, so I'll be posting this for others to also benefit from the discussion we had, and I'm sure that most of our students have benefited from this session. Thank you so much.
It's a pleasure, and thanks to Dr. Ezra for everything, and for everyone else there, good luck with your startups, and wish you the best. It's exciting.
Yeah, good. Thank you. Have a good day.
Assalam.
Bye. Ma salama.